The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, AFTA friends, and thank you very much for joining us on our webinar today. Today's webinar is focused on the rent relief package announced by the federal government and that will be rolled out via the various states and territories. My name's Joanne and I'm a member of the AFTA team, and I'm very pleased today to introduce Courtney Duddleston, who is Head of Strategy and Finance, and Courtney will be taking us through today's content. This webinar will be recorded and will be placed on the AFTA website for your viewing pleasure at a later time, or if you have any colleagues that you think would benefit from it. So just go to afta.com.au to find this webinar recording and other webinars that we've had. You are in listen-only mode. However, if you have a question, please use the question toolbox and we'll allocate some time at the end to address these questions. Courtney, I think that's it from me, so I'll hand over to you.
Well, thank you, Jo, and good afternoon, everyone. It's great to be able to present this webinar again. So for those that have not seen this before, welcome, and I hope that the presentation today will help to unpack this package for you. And for those that have already heard this, well, welcome back, and I do hope that the rerun today will give you an opportunity to further understand this and hopefully answer some of your questions that might have popped up in the last week or two. So on the agenda today, I'll help to set the scene first and provide some background information on the announcement that was made earlier this month. We'll then dive a little bit deeper into the new code of conduct and the key principles within this code. And now, as someone here may be aware, on Friday last week, New South Wales was the first state to pass regulation around the code, the retail and other commercial leases COVID-19 regulation of 2020. So we will go through in quite some depth how all of this applies. And now keep in mind that this is only applicable to New South Wales tenants. However, now that New South Wales has passed regulation, I expect that other states and territories will soon follow. And I'd also expect that the regulations in each state and territory will be of a similar nature. And then to try and put it all into context for you, I've included some examples of how it would work practically in your business. And we should have some time at the end for any questions that you might have. So we know that businesses are still having to pay their landlord, even if their workplace has shut down or their revenue has reduced to zero, which in the travel industry is certainly the case. We're seeing businesses face the perfect storm, a drop-off in revenue coupled with continuing fixed costs, one of them obviously being rental obligations. And so while commercial tenancies are regulated at the state level, by releasing this new code of conduct, the government has essentially set a standard for sensible and pragmatic solutions for landlords and tenants to work together. So earlier this month, the National Cabinet announced a mandatory code of conduct, or the Commercial Tenancies Code. Essentially, the code is intended to mandate a set of good faith principles to be applied to commercial, retail and industrial leases. Eligibility for the code is based on a business's eligibility for the JobKeeper payment. So that being, they're an SME with an annual turnover of up to $50 million and they have experienced a downturn in their business. The objective of the code is for a landlord and a tenant to share in a proportionate, measured manner the financial risk and cash flow impact during the COVID-19 crisis. It's about seeking to balance the interests of both the landlord and the tenant. So it's expected that a landlord and each eligible tenant will negotiate a tailored, bespoke and appropriate temporary arrangement on a case-by-case basis. And it's important to highlight that while this code has been announced, if you've already looked at what you can afford and you have been able to identify a solution with your landlord that you are both satisfied with, then that's completely fine. The introduction of this code is about ensuring that both a landlord and a tenant essentially come to the party and work together to ensure that both carry some of the burden. So what are some of the actual provisions under the mandatory code of conduct? Well, let's run through some of the key principles. There will be a proportionality to rent reductions based on the decline in turnover to ensure that the burden is shared between landlords and tenants. And I will go into this further later on with some examples to try and really put this principle into context for you. Landlords will not be able to terminate leases for non-payment of rent. Tenants must continue to comply with their lease obligations, otherwise tenants will jeopardise the protections that are provided by the code. There will be a ban on landlords passing land tax to tenants and a ban on landlords charging interest on unpaid rent. There will be a prohibition on penalties for tenants who stop trading or reduce their opening hours. There'll be a prohibition on landlords making a claim to a bank guarantee or security deposit for non-payment of rent. Landlords should allow tenants to extend the lease for the period the subject of rent deferral. And lastly, there will also be a freeze on rent increases. So I've tried to break this down for you and we'll go through what we know so far. So will your landlord reduce your rent bill? Well, the mandatory code of conduct that was signed off by National Cabinet includes a provision that will force commercial landlords to accept rent reductions in proportion to a tenant's decline in turnover due to the COVID-19 pandemic. This will be achieved through a combination of rent waivers and rent deferrals. Tenants are being encouraged to share turnover information with their landlord to enable negotiations about how big rent deductions should be. Although the government has been clear, this measure does not remove a tenant's obligation to honour the terms of their lease. Landlords are required to offer tenants at least 50% of their rent relief as waivers over the course of the pandemic period and the remainder in deferrals. Deferrals are required to be covered over the balance of a tenant's individual lease term. So meaning, for example, tenants with 3 years left on their lease will be able to gradually pay deferred rent over the course of their agreement. And those with less time on their lease, so for example, 6 months, you would have 2 years after the pandemic period is over to pay the deferred rent. So the bottom line is landlords cannot refuse requests for rent relief to SME tenants that are eligible for the JobKeeper scheme. Waivers and deferrals will be negotiated individually, but must follow the terms of the mandatory code. So how do you know if your business is eligible to negotiate under the new code? Well, small and medium businesses with $50 million in annual turnover or less, which are eligible for the JobKeeper wage subsidy scheme, can negotiate under the protections of this new code. And we know that the eligibility criteria for the JobKeeper scheme involves showing your turnover has declined at least 30% on a comparable period a year ago of at least a month, which I believe encompasses pretty much all travel agencies in Australia. So the bottom line, businesses eligible for JobKeeper payments can negotiate under this code. So even after the COVID-19 pandemic, can a landlord still evict a tenant? Well, National Cabinet agreed to a nationwide moratorium on evictions in late March, which means small and medium business tenants cannot be evicted from their premises for a period of 6 months. The mandatory code introduced this month also includes a provision that will prohibit landlords from terminating leases or padlocking stores for the non-payment of rent. Now we know that the Morrison government has been very clear that it expects tenants to honour the terms of their lease and pay rent where possible. But the intention of the code is to prevent landlords from evicting tenants for non-payment of rent during the pandemic period after the moratorium expires in 6 months. And so the bottom line with this is that your landlord cannot evict you for non-payment of rent during the pandemic period and must comply with the eviction moratorium, which is slated to last 6 months. Tenants are also protected from any rent increases during the pandemic, with the mandatory code including a specific provision that freezes rent increases. So commercial landlords are prohibited from charging penalties to tenants who stop trading or reduce their opening hours over the course of the pandemic. And they're also banned from passing on land tax to tenants and from charging interest on any unpaid rent. After the pandemic period, and there is no concrete date for when that will be, landlords are free to resume rent increases along with the terms outlined in individual lease agreements. So the bottom line, rent increases have been frozen throughout the pandemic period, and all additional penalties are gone too. So who exactly is enforcing this, and what happens if your landlord does not cooperate? Well, state and territory governments are ultimately responsible for commercial tenancy arrangements, which is why each jurisdiction must pass their own law, giving effect to the mandatory code of conduct. So enforcement will be left up to the state and will be overseen through a binding mediation process. And so ultimately, this is about both parties coming together and negotiating. Binding mediation will enforce breaches of the code, but it will look different depending on where your business is based. And so that brings me to my next slide. On Friday last week, New South Wales passed the Retail and Other Commercial Leases COVID-19 Regulation 2020. So as I did mention earlier, it's the state and territory governments that are responsible for commercial tenancy arrangements. New South Wales is the first to pass regulation, and I expect that the other states and territories will follow shortly. So I will go through the New South Wales regulation. For those members who are from a different state, you still may find this really helpful, as one would expect that the other states will follow through with something of a similar nature. So ultimately, we'll have to wait and see what they will come out with. So this new regulation amends two current regs, the Retail Leases Act of 1994 and the Conveyancing Act of 1990, to incorporate and reflect the principles of the code with respect to commercial leases. So the purpose of the regulation essentially is to give effect to the code, and particularly to prohibit and regulate certain enforcement rights of landlords during the COVID-19 pandemic period, and to require landlords and tenants to renegotiate the rent and other terms of retail and commercial leases in good faith, having regard to the code before any enforcement action can be commenced. So the regulation takes effect on 24th of April 2020, and it is repealed automatically on the 24th of October this year. So that being 6 months after it commenced, which is the prescribed period. The regulation defines a commercial lease as a retail shop lease under the Retail Leases Act, or a commercial lease under the Conveyancing Act. The regulation applies to tenants if they qualify for the JobKeeper scheme and the turnover of the tenant was less than $50 million in the 2018 to 2019 financial year. So now if you're a franchisee on here, it is the turnover of the business conducted at the actual leased premises. And if the tenant's a corporate group, then it would be the turnover of the group. The regulation also prohibits and regulates the exercise of certain rights of landlords relating to the enforcement of leases during the COVID-19 pandemic period. And lastly, it requires landlords and tenants to renegotiate the rent and other terms of their lease in good faith following the principles of the code before any legal action can be commenced to enforce certain terms of the lease. Now, there is an exclusion that I will just highlight, which are leases that are entered into after the after the date of the regulation. So any new lease that is entered into after April 24th is excluded. However, this exclusion does not apply to existing leases that are renewed or that would be extended after this date. Okay, so what are the prohibitions and restrictions that apply to the New South Wales regulation? So we'll run through the list of restrictions that apply to the landlord of an impacted tenant. A landlord must not take any prescribed action against an impacted tenant due to the failure to pay rent, the failure to pay outgoings, or not being open during trading hours that are in the lease. And then in the next slide, I will go more into detail about what those prescribed actions are. So a landlord must not increase the rent during the prescribed period. And remember, the prescribed period is the 24th of April to the 24th of October, so that being 6 months. A landlord must not take action after the prescribed period for any failure to pay a rent increase, which would have otherwise applied during that period. If an impacted tenant pays an amount for land tax, statutory charges or insurance, then a landlord must pass on the appropriate proportion of any reduction that they receive to the tenant. Anything an impacted tenant is required to do or not to do under either Commonwealth or state COVID-19 pandemic laws. So that may be so that's, for example, could have been to close up. That does not constitute a breach of a lease and does not allow prescribed action to be taken by a landlord. And lastly, none of the above here on this list prevents a landlord and an impacted tenant agreeing to a prescribed action being taken. So the New South Wales regulation has come out, and part of that is what's called a prescribed action. So that is, the landlord of an impacted tenant must not take action under a lease, seek orders, or commence proceedings of any of the prescribed actions. So we'll run through the list of these. So this includes the eviction of an impacted tenant, recovery or actions of possession of the premises, the seizing and the forfeiture of goods of an impacted tenant, making a claim for damages against an impacted tenant, the charging of interest or other fees for any unpaid rent, the recovery of a tenant's bank guarantee or their security bond that has been provided under a lease, or a claim under any other guarantee. The landlord cannot terminate the lease of an impacted tenant. And lastly, they cannot commence proceedings of any other remedy that is otherwise available to a landlord. So what comes next? Well, at this stage, for the exception of New South Wales, we are still awaiting implementation of the code by all other states and territories. If you're a tenant based in New South Wales, then our suggestion would be to familiarise yourself with the principles of the code. So we did go through these earlier, and they will be included on the slide deck when we send around a recording of this webinar later today. We'd also suggest that you seek legal and accounting advice specific to your circumstances. You work through your financials and identify an affordable solution that you can put forward to your landlord, and begin instigating negotiation in good faith and in accordance with the code. If you're from another state or territory, then my suggestion would be to start doing the same. Get on the front foot with your landlord, start prepping your financials now, get legal and accounting advice on the application of the code, and speak to your advisors about what is an affordable solution for you. And if your landlord's playing hardball, let's say, and they are denying you a rent reduction, then they're not following the principles of the code, and that to me is not good faith negotiation, which forms the key purpose of the code. So that also means, therefore, that they cannot take on the prescribed action that we went through earlier, like the eviction of an impacted tenant or the seizing of goods. So we'll try and bring all of this to life now with a couple of examples reflecting the application of the principle of proportionality and how it would work practically in your business. It's important to note that this scenario is an example only, and the circumstances of each landlord, tenant and lease are different and are subject to negotiation and agreement in good faith. So let's say Mary owns a retail travel agency and has a commercial lease with a suburban shopping centre. Last year, Mary transacted $2 million through her business, making a gross profit of $200,000. She's currently paying $45,000 per annum in rent. So Mary has established that due to COVID-19, she will have to temporarily shut her doors and will experience a 100% loss in turnover in her business. So Mary is eligible to be provided with cash flow relief in proportion to her loss of turnover experienced. That being, a 100% loss in turnover would result in a guaranteed 100% cash flow relief. So under the code, Mary is eligible to receive half as rent-free or a rent waiver, that being half of her annual rent expense, so $22,500, and the second half as a rent deferral, so the remaining $22,500. So this deferral of rent is to be recouped over at least 24 months in a manner that's negotiated by Mary and her landlord. And both parties will need to ensure that any repayment of the deferred rent does not compromise the ability of Mary to recover from the crisis. So let's look at another one. Justin owns a travel agency and has a commercial lease agreement for his office space in the Sydney CBD. Last year, his business transacted $38 million in sales, of which $8 million was his gross income or his turnover. He currently has 3 years remaining on his lease agreement and he's paying $170,000 per annum in rent expense. Justin has established that due to COVID-19, his business will experience a 60% decline in revenue, guaranteeing him 60% cash flow relief to his business. So 60% of his rent expense is $102,000 per annum. Justin's cash flow relief would be provided as half as rent-free or a rent waiver, being $51,000, and the second half as a rent deferral, being the remaining $51,000. And again, this deferral of rent is to be recouped over at least 2 years in a manner that's negotiated by both parties, and it does not compromise the ability of Justin's business to recover from the COVID-19 crisis. So we're coming to the end, but I've got one more example that we'll just run through. Sally runs a travel agency, Sally's Travel, Pty Limited. She carries on a medium-sized travel agency in a shopfront leased from Property Holdings Proprietary Limited or the landlord. The lease has 5 years remaining and Sally is required to pay $10,000 per month in rent. As a direct result of COVID-19, Sally's revenue has fallen by 40%. So under the code, the landlord will be required to provide an ongoing rental reduction equal to 40% of the monthly rent. So that is 40% reduction at $10,000 per month equals a $4,000 monthly rental reduction. At a minimum, the landlord is required to provide 50% of the rental reduction by way of a rent waiver, so that's $2,000 per month, and the remaining 50% by way of a rent deferral, being the remaining $2,000 per month. So the rent waiver amount is no longer required to be paid by Sally's Travel at all, and the rent deferral amount is to be paid by Sally over the remaining term of her lease, of which she's got 5 years remaining. So I hope that the rent relief rerun today has helped, along with the outline to the New South Wales regulation, and we hope it's been able to clarify some of your questions around the topic. And as more of the states and territories begin to pass the regulations, we'll be sure to communicate this with everyone on here. So Jo, I might hand control back to you to see if we've got any questions from members.
Thanks, Courtney. We do have a few, not too many questions, but a few here. Simon would just like to clarify. He said, is the rent relief provided over 12 months and not the 6 months of the pandemic? I think what the confusion here is, and correct me if I'm wrong, Courtney, but it is over the next 6 months is the rent relief, but it's based on your, I guess, your rent payment, what you would pay over the 12 months, or broken into monthly amounts.
Yeah, no, that's correct. And it's important to note that New South Wales has issued the prescribed period as being 6 months. So this code essentially will be running until for another 6 months. But ultimately, it also comes down to the negotiations that you can have with your landlord and what you deem to be a period. But at this stage, it seems to be about 6 months.
Thanks, Courtney. Simon, you're not the only one that's asked that question. I think because it's based on your rent repayment for a year broken into monthly amounts, there's some confusion over, if it's a rent relief for 12 months, but it's not, it's 6 months.
Right, correct.
I've got a question from Maria who's asking about the Sally example, and she said, why is Sally not required to pay the $2,000 waiver on your example? Maybe we'll just jump back to that example.
Yeah. So the rent waiver, it's no longer to be required to be paid by any tenant in accordance with the code. So the deferral amount is required to be paid over the remaining lease of the term, but because it's a rent waiver, Sally's no longer required to pay it to her landlord. So this code essentially, I mean, it's come out, it's about the tenant really, and there are other ways for a landlord to be able to get relief, and so that's why they encourage them to speak to their banks. They can get other government relief, but essentially the code is around, look, it's working in good faith with a tenant and a landlord, but it's about how the tenant can be helped by way of their rental reductions during the COVID-19 pandemic period.
And I think maybe there's just a little bit of confusion here, Maria. All the examples Courtney provided had some portion being waived and some portions being deferred. So Sally's example is no different to the others, where a portion has been waived and not required to pay, and a portion is deferred. I hope. Yeah,
that's right. And it clarifies. Yeah, you're right, Jo. And it was just a matter of putting Sally's in a different sort of format to give it a bit of looking at it from a month-to-month perspective, as opposed to the other examples which were on a per annum basis.
Great, perfect. I think that answers or clarifies things. Simon has asked a question here, and I guess he's asking for advice from us. What if your landlord will not negotiate until you as a business have been proven to be eligible for JobKeeper? So he's asking, is there any idea when we would expect to receive confirmation of JobKeeper eligibility?
Well, the payments will be flowing from next week for JobKeeper. So I assume you've done your enrolment and you would have nominated your eligible employees. So, I mean, to be honest, that I would be providing all of that information starting now to the landlord. I would provide them with evidence that you've enrolled your business for JobKeeper, evidence that you've nominated your employees as eligible JobKeeper employees. That's the information I'd be providing to them now. I wouldn't be waiting until next week when the money starts flowing.
And I think here, your landlord's perhaps playing hardball here. They're looking at elements within the code to pull you up on and defer that negotiation, which I think is unfair.
Yeah.
Hi, Peter. A question from Peter around at which point you can negotiate for rent relief. So, of course, we've seen a decline in business earlier than when this code was implemented. So Peter's asking, can the landlord ask for full rent for the month of April and then start negotiating on from the 24th of April when this code was implemented? Because obviously Peter has his office in New South Wales.
Okay.
And I probably would respond, Peter, by saying it's up to you guys to have that discussion. I think if you've demonstrated that your business has declined earlier, which obviously being a travel agency it would have, I think that's where you need to negotiate firm, because it's taken some while for the government to get to this point to really support tenants. But of course, they've been saying it for over a month, saying guys get together and have a chat. And I think the very reason that the chat hasn't happened is why they've had to introduce this code. So if it was me personally, I would be fighting from April, not from the 20th of April.
Agree, Joe. And I think it really comes down to being really transparent with your landlord. And the government has encouraged tenants to share their financials, in a more high-level detail, but to share the level of drop in revenue and the financials, the projected revenue over the next 12 months, share that information with your landlord. That way you can really work on a bespoke and appropriate negotiation and lease restructure that you can both work with. And that's what it really comes down to. You've got to have that transparency, I think.
Very true. A great question from Kieran. He said, we have a ground shop front and an upstairs office. Both are on separate leases. The upstairs office is used for processing, administration, staff room, and freelance contractors. Is the upstairs lease eligible? I've got an opinion. Do you have an opinion, Courtney?
Well, I do. I mean, I would say it would certainly be eligible. I mean, no doubt the business is connected.
Yeah, I would have said the same, Kieran.
Yeah.
I mean, whilst you've got two separate leases, you've got one business that you're operating and your business has had a decline, so it doesn't matter how you allocate your day-to-day jobs across the two premises, so definitely.
Yeah, I'd be speaking to the landlords of both of those premises and requesting a renegotiation. Absolutely.
Ben just wants to clarify the pandemic period, and from what the government has said and the support packages available, it is really sort of that March to September 6-month period. And
yeah, I mean, and as I said earlier, I mean, when the pandemic period ends, we don't have a concrete date for that. The government hasn't released one. We don't know. We don't have the answer to that. All we can work right now is, particularly in New South Wales, is the prescribed period, which is the 6 months. And I expect many of the states will follow suit. One would expect that their own regulations will be of a similar nature. So I'd be working around that. But unfortunately, at this stage, who knows when the pandemic period will end? I certainly don't.
Yeah.
I don't have a crystal ball.
I think what the government came out with is the 6-month plan, and no doubt as we get closer towards that 6-month mark, there'll be a reassessment of the economy and strategies put in place to support and uphold the economy going forward. We have a question from Michelle who just wants to clarify the waiver and the deferred amount. So I might just reiterate it here, Michelle. And hopefully it's helpful for everybody. What Courtney's demonstrated in this webinar is that depending on your reduction in turnover, you're able to get that percentage reduction in turnover as a reduction in rent. So if, for example, your rent, let's say, for the purpose of a big figure, let's say it's, well, actually, let's use Sally's example here. The rent is $10,000 monthly. So, but Sally's seen a 40% reduction in her revenue. So that 40% reduction can be applied to the $10,000 that's paid monthly in rent. Then that $4,000 is split into two different amounts. 50% of that, or $2,000, never has to be paid again. That's waived. And that's really great. The other 50%, the government's saying you do have to eventually pay it, but you're getting a longer period to pay it. So
yeah, that's great, Jo. And look, we're getting a lot of questions specific to businesses. Jo will send me all of the questions. I'm happy to have a chat with everybody and just really try and break it down for you. We can put a couple of your own numbers in there if it helps, because it is quite a lot to get your head around, and especially if this is the first time that you're seeing the presentation. So if you do have a specific question trying to get your head around the numbers, then I'm happy to take a conversation offline with you and try and put some context around it in regards to your business, if that helps.
yeah, I think because, and Michelle, maybe flick us your example, and I can see that, Teresa, you've also asked this example in Sally.
Mm-hmm.
So it's not 6K, it's the, yeah, sorry, I'm gonna get people confused if I keep going, but I think, Teresa, Michelle, send us your examples and we can,
yeah, I'd be more than happy to take it offline and run through. I know it can be a lot to get your head around for the first time, definitely.
and sorry if me going over the content just confused everyone. That wasn't my intent.
You're doing a great job, Jo.
Okay, we've got a question from Claudia, who's said that, where's your example? That she's also the landlord for one of her stores. Is the government going to help landlords?
Look, the code's really aimed at tenants. And if you're a landlord, the suggestion would be to see what other measures are there for you. Essentially, that means, what can you afford? So, I mean, if you're sorry, did she say she's a landlord and the tenant?
Claudia, you're the landlord and the tenant. Here she's just saying that she is the landlord of one of her particular.
Yeah.
So I don't know if she's operating out of that or if she's got someone operating, but. Yeah,
so really it's about the landlord speaking to the bank, seeing what other government measures they would be entitled to. But I mean, ultimately as well, it's about the landlord and the tenant working together about what is an affordable solution for both parties. And this also comes down to the landlord being really transparent with the tenant too. The landlord needs to sort of put on the table, well, this is what I can afford to give you, this sort of reduction, and this is why, because, this is my balance sheet, my liabilities. It's about being transparent, working out an affordable solution both parties can work towards for the next 6 months, for the next 12 months.
Johnny has asked, what if your landlord refuses to negotiate with you? I've got an opinion, Courtney.
Well, my opinion is that they're not compliant with the code. That's certainly not in good faith. And I'd be asking why too.
And I think, really? I think, Johnny, personally, I would go to the landlord and say, until you negotiate with me, I'm not paying rent. And if you want to take it as far as putting a claim into the tenancy tribunal, because I'm not sure what state you're in, but when it gets legislated, they will be required to negotiate. So I wouldn't be paying rent till they negotiate, and they can't kick you out.
You're right. I was going to say, if you're an impacted tenant of COVID-19, the prescribed actions state that you actually can't be evicted.
Hey, Courtney, I've got a great question from Tony, and I'm pretty sure I read it somewhere in the code, but it might be fresher in your mind. If your rent is broken down into the outgoings and the rent, is it the rent relief only provided on the rent portion? Do you know what happens with the outgoing component?
No, so I think the outgoings, as far as what I've been reading, it's in regards to rent. If the landlord was to receive a reduction for some of the charges that they would then pass on to the tenant, so for example the land tax, so that form part of the outgoings, then the tenant would also be required or be entitled to a reduction in that. But essentially it's about a reduction in the rent.
And another question here from Claudia. She's just asking, what's the best way to establish a fall in revenue? Her landlord seems to think it should be based on BAS, which covers obviously the June to March. But is there any particular guidance as to how the fall should be calculated?
Yeah, look, you should really be referring to the JobKeeper eligibility and how you determine your reduction in turnover for that scheme, because that scheme will then entitle you to be part of the code. So I'd be looking at the rent reduction along with that.
Thanks, Courtney. Let me just have a read of a couple of other questions. I've got a question from Michelle here asking, is it legal if your landlord wants 12 months proof of monthly sales along with a proof of decline over the last few months?
There's nothing that says it's not legal, and I'll talk from experience because at AFTA we've gone to our own landlord and asked for rent relief. We've supplied them with the last two sets of financials. We've supplied them with our pre-COVID-19 projections and our now our COVID-19 projections. So again, I think it's about being really transparent and providing everything that you can to justify your decline in turnover and your eligibility for a rent reduction that you feel comfortable providing as well.
Yes, because as you mentioned earlier, Courtney, it's about mutually discussing and coming to a agreement that suits both parties. And I think if you have seen a decline, which we all have, open book with them. Get your accountant to do some high-level figures for them. Because you've got nothing to hide but everything to gain from getting that rent relief. So, Courtney, Cheryl's wanting clarification. If a business has absolutely nil income, so they've lost 100% turnover, and this goes back to our first example, does that mean no rent needs to be paid?
Well, you'd be entitled to a 100% rent reduction, but then half of that would be as a rent waiver and half would be as a deferral. If that makes sense. I'm happy to take that conversation offline. It can be a little bit hard to articulate and hard to digest. So I'm happy to walk through that and explain the difference between the entire cash flow relief and then part of that being as a waiver and part of that being a deferral.
And Cheryl, also I encourage you to look back over the examples and see if you can overlay that example with your business. Let me just read a couple of other questions, guys. Sashin is asking if this is for commercial tenants only and not private households. Yes, this mandatory code of conduct is only for commercial tenancies. Oh, great. Rosalina's just mentioned that if anybody is having particular issues negotiating with their landlord, they can go to the Small Business Commissioner, and she's obviously in South Australia and just said that the Small Business Commissioner in South Australia can assist you come to an agreement. And I'm sure that there's one of these in each state. So thanks for sharing, Rosalie.
Great.
We've got a couple of questions, Courtney, in terms of leases expiring soon, negotiating new leases.
One. Yeah. So, sorry, go on, Jo.
I guess they're asking if leases are ending 30th of June, what's the best way forward?
Yeah. So, I mean, look, ultimately, again, it will be up to what state you're from. We know in New South Wales, so long as you're in an existing lease as of the 24th of April, then you can apply the code or the regulation. That applies to the renewal of an existing lease during the prescribed period. So, for example, if it was in June and you decided to renew your lease, then you would still be eligible to apply the code to that or the regulation. And also if you were going to roll over an existing lease. If you were going to get into a new lease after the 24th of April, then you would not be eligible to apply the regulation or the rental reduction to your lease.
Thanks, Courtney. Okay, Jill's got a question around the fact that she owns offices under her own superannuation fund. And Jill, I want to acknowledge your question, but I do think you should talk to your tax accountant for this one. So please refer to your accountant on the best way that you should manage your particular situation. But I just want to acknowledge, thank you for the question. Okay, I'm just digesting these guys, so bear with me. Okay, I think we've answered that one. This is good. We're getting through them. Okay, question from Andrew. So I assume, Andrew, you're talking about being a travel agency and perhaps negotiating a new lease. But Andrew said, are we allowed to place a clause in the lease where the said reduction in the lease for the first 6 months to allow an extension of the reduction amount if government approves or such new dates of the pandemic? Sorry, everyone, that sounded very confusing.
I might have to take that question offline, Jo. I'm not sure I was able to digest that one properly.
I realised after I started reading it that was probably...
Yeah.
I think...
And also, I mean, I'll make a note that, I mean, you know, it's not we're not here to give you legal advice, obviously. Anything that is specific around putting a clause in an agreement or anything, my suggestion would certainly be to seek professional legal advice around that. But happy to take the question offline and maybe just have a bit of a chat and try and put a bit of context around it, perhaps.
Yes, and I think too, yes, sorry, Courtney. I'm just having a look at some others. I think too, what I was going to say is that Courtney's demonstrated here that a code has been put in place to provide a platform for negotiations to start taking place. So what that looks like, what you negotiate in terms of amount and terms is completely in your hands. When you choose to start that rent relief from is all up to you in your negotiations. So think about what you need as a business owner, think about what you want, and like really put that forward. And as Courtney said, talk to your accountant to get advice around how it's going to affect your cash flow, or for any documents that you might need to provide evidence of your scenario and eligibility. And then also, if you need, talk to a lawyer around your rights for this. If you need a supporting letter, or as someone has suggested, go to that Small Business Commission and get support. So the code's in place, the power's in your hands, so start the negotiations. The code, the mandatory code itself is really easy to read, and we've put this on the AFTA website. It's under the COVID-19 section. It's definitely worth downloading. It's in bullet points, and it's really set out, it's clearly set out in plain English. And by understanding it, you'll be more equipped to have negotiations with your landlord. So I really encourage you to take that ownership and read and understand it. We might leave the webinar there. Courtney and I have a few people to loop back on, and we'll, of course, download all the questions and make sure that we haven't missed anyone. So thank you very much for your time. We'll put this webinar up online and along with the slides, so please feel free to revisit all these various examples.
Thanks, everyone. Appreciate you joining us today.
Look forward to having everyone on tomorrow's JobKeeper webinar. Bye for now.
Good afternoon.